There
Hold on
is
a
no
second,
power
man.
in this.
Okay, hang on. I may vacate my dismissal on this.
This case starts like a routine landlord-tenant dismissal, and within minutes, it turns into something far more serious. What you're about to see is not just a paperwork issue or a missed hearing. It becomes a confrontation over basic living conditions, legal protections, and a decision that forces the court to slam the brakes on what looked like an easy win for the landlord. On one side, you have a tenant with low vision, appearing alone on a virtual docket, believing her case is over. On the other, a property owner whose attorney fails to appear, a mistake that nearly ends the case instantly, but then comes a revelation no judge can ignore. Electricity shut off, heat gone, winter approaching, and suddenly dismissal is no longer an option. Watch closely how Judge Simpson pivots in real time, how a single fact changes the legal posture of the entire case. Ask yourself as this unfolds, if you were in her position, without power and without representation, would you even know what to say to stop this from ending right here?
Court calls the case of Northwood property versus Brienne. Is it Porcia?
Yes, can you hear me now?
Yes, I can hear you.
Okay, I apologize. I have low vision. I can't see I can't see the screen. So
Okay, it's okay. The plaintiff's attorney is not here. I guess they're saying he signed in, but hasn't signed back in. You're here. Are you moving to dismiss this case, ma'am?
what does that entirely mean?
That means this case would be over at least.
Does that mean that I would need to be served all over again?
Well, they'd probably have to start over. They'd have to serve you with something.
Okay. Then yes, I would like to dismiss.
Case dismissed.
Thank you
That's
so
without
much.
prejudice. They may come back and they may try to do something, but they'll have to. They'll at least have to try to start this case over and move to set it aside. But you'll get an opportunity to be heard if that happens. Okay.
Okay. Moving forward, what do I do now?
What do you mean?
Do I stay put? Can I tell you about the case or?
No, you can't tell me about it. But yeah, you can stay where you are because I'm not signing. This case is dismissed, so I'm not signing any orders telling you have to do anything.
Okay. Thank you so much.
Thank you. You have a great
do you have any advice about, I'm sorry, do you have any advice about how I should move forward?
No, I can't give you legal advice.
Okay, what about the fact that the power has been turned off prior to ever receiving any paperwork?
This is the turning point. The tenant introduces a fact that immediately shifts the legal gravity of the situation. Loss of electricity, especially heat, is not a minor inconvenience. In most jurisdictions, it's a habitability violation and potentially an illegal lockout tactic. Judge Simpson pauses, reassesses, and you can hear the shift in his tone. He's no longer managing procedure, he's evaluating harm. This is where courts draw a hard line. Even if rent is owed, even if a lease has expired, a landlord cannot force a tenant out by shutting off essential utilities. That's not negotiation, that's coercion. And here's the engagement question. Do you think landlords who do this should face automatic penalties, or should courts always investigate intent first?
There is no power in this.
Okay, hang on. I may vacate my dismissal on this, but hold on. All right. Are you sight impaired, ma'am?
Yes.
Okay, and you're telling me now that the heat is off?
Yes, on December 19th, before ever receiving any warning, they completely turned the power off, and I've been living here with no power since then.
Your goodness. So do you have a lease there? I do see it. Hold on.
Yes.
Okay, your lease expired, it looks like. Are you there by yourself, ma'am, or?
I have my best friend that's here that helps me with my vision.
Got it.
He's present.
So you've been without electricity for
just about a week,
and that's
yes, and that's actually about 2 months ago. My landlord turned off the power in the back of the house, which was the room that I was renting out. So I had to move my bed out to the kitchen area because that was where she just cut half of the power. So I had to move into the living room area to stay warm. And then now on the 19th of December, she fully cut off all the power. So
Was she supposed to, I'm trying to look through your lease real quick. Is it up to her utilities? Hang on. So you're sure she shut it off?
yes, I asked her about it and she was coy. So I don't know how I could prove that it was her giving. I don't have proof of it being specifically her.
Okay,
But there's
let's do,
people that live above me that they have power. It's just the bottom part of the apartment that has been shut off. So this whole
okay,
building is not completely without power, just where I reside.
I got you. So here's what I'm going to do, ma'am. I'm going to vacate the dismissal. I'm not going to dismiss the case. Okay.
This is judicial authority exercised correctly. Judge Simpson reverses his own dismissal, not emotionally, not impulsively, but based on newly revealed facts. Vacating a dismissal is not common, and judges don't do it lightly. But here, the reasoning is clear. Allowing the case to end would leave a tenant without protection while living in unsafe conditions. Notice how he frames it. You can't continue like this. That sentence matters. It signals the court's duty to prevent ongoing harm, even before final liability is determined. This is also where many landlords miscalculate. They assume procedural wins override conduct. They don't, and they never have.
Because you can't continue like this, and it's about to get very cold out there soon.
Okay.
Here's what we're going to do. Their attorney signed in, but then signed out.
Okay.
So, I don't want to put you out to the 10th, which is my next date, with the circumstances as you're explaining them. Follow
Okay.
that? So,
Yeah.
what I want to do. Okay. I want noon. Yeah. So here's what I want you to do. I want you to sign back on at noon today.
Okay.
Okay. We're going to try to get to the attorney in this to tell him that we want to see him here at noon today.
Okay.
And let's see if we can get some of that resolved. Okay.
Okay.
All right. So sign back on at noon. I'm not dismissing your case at this point. Sign back on at noon. We'll get the attorney here and see what we can do. All right?
Okay.
Okay.
Okay. Thank you so much, sir. Have a good
You're
New Year.
welcome. You're welcome. We'll talk to you at noon. Okay. Take
Okay.
care.
Brianne, Portia?
Your Honor,
Mr.
I apologize for this morning. I was having technical difficulties. I did become aware of what occurred, and I believe I have rectified that situation. I need to get confirmation from Brianne or the tenant. Has there been any change since this morning, Brianna?
Yeah, it's Brianne. Yes, thank you. The power is back on. Thank you so much for that. It's
Okay, so the
life-saving.
power is back on. Well, I'm going to have to ask the question so that we know. I would certainly just then go ahead. I think this was going to be dismissed, right? It was going to be dismissed. However, the real question for the court becomes 2, 3, 6, 7, 8, 9. Sorry, 1, 2, 3.
I can't read what
6,
you
7,
put in the
8.
chat.
It's okay. It's okay, ma'am. What was in the chat? What? I'm not sure what got put in the chat, but it was somebody else. Okay.
Oh,
So
okay.
it's okay. Here's what the issue is. who shut off the electricity?
Now we see the landlord's attorney attempting damage control. The explanation offered, that the wrong unit was shut off, is telling. Even if true, it doesn't erase responsibility. Utilities in the landlord's name mean the landlord controls access, and courts take that seriously. The judge doesn't accept vague explanations here. He's focused on duration, impact, and accountability. And this is where credibility becomes critical, because moments later, the tenant states the landlord was aware the power was off. That contradiction matters. Judges remember inconsistencies. Viewers should ask themselves, if this had stayed dismissed, would this information ever have been examined at all?
I would have the understanding that it is in the landlord's name. And there are a couple units in that property, and I think the wrong one got turned off. And it was never brought to the attention that it was her specific unit.
Your Honor, may I say something?
Yes, ma'am.
I reached out to my landlord and I did get a response. So she was aware that the power was cut off the day after. I technically did not even receive my summonings because, like I told you previously, I have a partner here that helps me with my vision. And when I was supposedly served my summonings, I technically wasn't even served. They knocked on the door and I wasn't available, and they threw the paper at my partner.
Okay.
And,
all right, I'm not going to worry about that. Here's what I'm
Right.
getting at. I guess I was getting at. Mr. Drukas, I'm
Yes,
not going
Your
to dismiss this. I'm going to set this over to the 10 because it may, and you may want to have your client and attempt to try to negotiate it. But if she's without power for those 9 days, your client may very much owe about $1,800 minimum to the defendant.
This is where the financial math flips. The landlord came in claiming nearly $3,500 in unpaid rent, but Judge Simpson introduces statutory consequences, potential damages owed to the tenant for unlawful utility shutoff. That $1,800 figure isn't sympathy, it's a legal floor. This is why the judge refuses to order escrow payments. Ordering a tenant to pay while the landlord may owe more would be legally backwards. It's also a warning shot to the plaintiff. Pursue this recklessly and the numbers could turn against you fast. Engagement question here. Should unpaid rent ever outweigh violations of basic living standards?
Is there any way that we can address escrow in the interim? Because this was a lease that ended back almost 6 months ago, or in August, and there have been no payments that have
I
been
asked
made.
for a bill and
Hold
I was never
on,
received.
ma'am,
Yes,
stop.
sir.
There's been no payments.
Yeah, there's been no payments for
Well, how much is the monthly rent?
the monthly rent is at 500.
So 500. And so how much is plaintiff claiming she owes?
Currently, we have a balance at 3480.
3480?
Correct.
Okay, well, I'm not going to have to put anything into escrow at this point because the issue is going to be your client may well owe her about 1,800 of that.
Okay.
And that's the floor of it under the lockout statute. So, I mean, she may indeed end up owing her more. So why would I have her pay escrow at this point in time? So
Well,
I'm
it would
not
be-
dismissing the case. We're going to resolve this issue or figure out how we're going to resolve this issue. I'm going to set this over to January 10th, 2025 at 2 p.m. in person.
Thank you, Ann.
Your Honor, where is this located?
At the service center by the Washtenaw County Jail, you know where we are, Hogback and Carpenter.
I'm sorry, what name? Hardback?
Hogback and Carpenter.
Hogback, okay, and Carpenter. I am
Well,
familiar with that.
if you say Hogback like that, then that means you don't know where you're going because everybody around knows where Hogback is. So here's
I'm not
all right.
I'm not from here. I just moved here, so
Okay, no, and I can tell when you said Hogback. Okay, yeah, it's here. It's over by the Washtenaw County Sheriff's Department.
okay.
Okay, you want me to give you the address would be 4133 Washtenaw.
Okay. You got that. Okay. Thank you so much.
Not a problem. We'll see you then.
Okay. Thank you.
Go ahead. What?
What will I need to go to? How do I don't know what. So I go there. Do I need anything?
What I've heard today, you just need to get here to the court hearing. We're going to try to flush out what we can flush out.
Okay. Thank you.
Okay.
Thank you so much.
All right. Thank you. Have a good New Year.
And my phone number is on the paperwork. If you can give me a call, certainly I'd like to chat before the next hearing.
Okay. All right.
Okay.
Thank you.
Okay. Thank you.
All right. Thank you.
This case ends exactly where it should, not with dismissal, but with accountability pending. Judge Simpson sets the matter for an in-person hearing, ensuring both sides are heard and the utility issue is fully addressed. The key takeaway is simple but powerful. Courts will not tolerate self-help evictions or utility shutoffs, regardless of rent disputes or expired leases. Procedure matters, but human safety matters more. This hearing preserved that balance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.